basically the regulation says that USCIS generally will not place somebody into removal proceedings, even like while they have a T visa pending, or if a T visa case is denied, unless the person has an egregious criminal history or they're a terrorist or a trafficker. So if you're not a terrorist or a trafficker and don't have a egregious, super serious criminal history, then denying a bona fide determination work permit should not result in a referral to removal proceedings. USCIS generally will not refer an applicant for T non-immigrant status for removal proceedings while the application is pending or following the denial of the application. Absent, so like unless there are serious aggravating circumstances such as the existence of an egregious criminal history, a threat to national security, like being a terrorist, or where the applicant is complicit in committing an act of trafficking. So unless it's an egregious criminal history, you're a terrorist, or I suppose a spy would also be a threat to national security, or where the applicant is complicit as like an actual trafficker themselves, you shouldn't have a bona fide determination denial resulting in a notice to appear for removal proceedings. And we have seen a case where a person didn't have any significant criminal history, like really no history to speak of other than some traffic tickets. And yet when immigration decided that case wasn't bona fide, they went through a full T visa decision. They decided to send a notice putting that person into removal proceedings. So why would they do that if generally they won't do it if the person doesn't have this serious criminal history? I don't know. I think they made a mistake. So in that case, fortunately, there was really good representation. Removal Defense Counsel communicated with ICE, the attorneys for ICE, and with the immigration judge before there was ever going to be like a trial in immigration court. Our office filed an appeal and a lawsuit as well against immigration, made it very clear that this never should have happened. And then ultimately, the immigration judge and opposing counsel agreed to jointly terminate deportation proceedings for that client. And then we won our appeal. So there are things like that can happen which are not fair. There's certainly risks to filing a T visa case, but I did just want people to understand that if the government's going to do something unlawful, you just want to be prepared to deal with what they've done that is inappropriate or incorrect or erroneous. And so now our steps are, look, if you're going to do a negative bona fide determination, are we going to go back to having to sue to get a full T visa decision then? Right? So a negative bona fide determination doesn't mean you're not going to win your case. It means that immigration hasn't issued a document that we want. And so now we want to push for full T visa approval, hopefully. And if that case isn't approved, if it's a case that we prepared, we believe in, we're going to want to do an appeal or even another lawsuit to try to win the case later. It's absolutely true that the T visa application process is a very long process. And I understand why some might say, let's not file for the work permit now. For our clients who get bona fide determinations positively in the approved work permits, it is life-changing. It's a huge benefit to get that. But we're also weighing the risk of, well, what happens if it's not a positive bona fide determination? So those are each very individual conversations that I think people need to have. And it is also possible that there is something in the immigration file, I wouldn't know what, that made the attorney go, in this one, we don't want to risk it. We're just not going to agree to file that one right now, and that recommendation may stand. So just know that I'm talking generally about how we're handling things, but there are also sometimes there's a reason for not pushing forward with it.